Thank you for joining us today. I'm Tom McMillan, the CEO of LEAD1 Association, and I want to welcome you to the LEAD1 Angle, where we discuss important issues in college sports with key players. Today, we're so pleased to have as our guest Mitt Winter. He was an attorney with the law firm Kennyhertz Perry out of Kansas City. And Mitt has had a very significant practice in the college sports area. So we're going to have a lot to talk about with him. Most interesting, he was a former D1 basketball player for William and Mary, which I think gives him a unique perspective on a lot of these student athlete issues. Mitt's had extensive legal experience in college sports, representing conferences and the like on litigation, governance matters, and he's dealt with many of the legal challenges that our conferences and our member schools face. So we're going to be talking about some interesting topics. To kick it off, we're going to start with the Alston case, which is recently the law of the land, which resulted in, as they say, a recent federal injunction. Let's start there, Mitt. Why don't you give our listeners some background on the Alston case and what it all means?
Sure. The Alston case is a case that was filed back in 2014 as a class action on behalf of FBS football players and Division I men's and women's basketball players. The case was alleging that the NCAA rule that limited athletic aid to the cost of attendance was an antitrust violation, and that the rules limiting the amount of athletic aid and benefits that schools are allowed to give to those athletes violated the antitrust laws. So the case was litigated for a number of years until March of 2019, when the trial court out in Oakland, California, the Northern District of California, Judge Wilkin, she issued her decision, and as part of that, she issued an injunction saying that the NCAA cannot limit the amount of educationally related benefits that schools can award to those athletes. In addition, the injunction said that schools have to be allowed to give cash or similar types of benefits for academic and graduation awards and incentives. So the trial court issued that injunction. The NCAA subsequently appealed that decision to the Ninth Circuit. The Ninth Circuit affirmed the district court's opinion. After that, the NCAA went to the Supreme Court asking them to issue a stay so that the Ninth Circuit judgment would not go into effect until it had a chance to appeal the Ninth Circuit's decision to the U.S. Supreme Court. The U.S. Supreme Court denied the request for a stay, and shortly thereafter, the Ninth Circuit judgment went into effect. And after that, that was when you saw the NCAA issue their emergency legislation, putting the Alston injunction into effect.
So what does this mean to our schools right now?
Sure. So there are two important parts of the injunction. The first is that the NCAA rules that were limiting the amount of educationally related benefits that schools could give to their athletes no longer exist. So now schools are allowed to give their athletes vocational scholarships. They are allowed to give them post-grad, undergrad, or graduate school scholarships. They are allowed to pay for study abroad programs. They can give their athletes paid post-eligibility internships. They can also give them certain items that are considered academic items, such as computers, musical instruments, and other tangible items that are related to the pursuit of academic studies, the way that that phrase has been termed in the NCAA's emergency legislation. So these are all things that schools can now give their athletes as part of their athletic aid. So these can be things that are promised to athletes in the recruiting process, or they can be awarded while the athlete is in school. The second part that's really important is the cash awards that are now allowed for academic incentives and graduation awards and incentives. So the uh, the limit there can be a limit on those cash awards per the injunction, and it relates to NCAA figures 16.1, 16.2, and 16.3 in the NCAA manual related to participation, championship, and special achievement awards. So the injunction said while schools have to be allowed to give these academic and graduation awards and incentives, there can be a limit. And it did not put a number on that limit. It just referred to these charts that are in the NCAA Division I manual. Um, so I added up those numbers this morning, and the number I come up with, this is an annual figure that a school could give to its FBS football or Division I men's basketball players. And the number I came up with is $6,935 on an annual basis for academic and graduation awards and incentives. The injunction and the NCAA's emergency legislation did not put any kind of criteria around what an athlete has to do to receive these awards. So that is something that's left up to the school or conference's discretion. If they want to say, if an athlete gets a 3.0 GPA this semester, they get X amount of dollars. Or if they graduate, they get X amount of dollars. Or if they're in good academic standing, they can get X amount of dollars. Those are things that the schools and the conferences have discretion to set their own rules on. The only limit is that it cannot be higher than that $6,935 limit. At least that's my calculation. There has been some differences of opinion on what that actual number is. I've seen as low as down around 5,600, and I've seen some people say no, that number is closer to 10,000. So that's also an issue that schools will have to look at a school level or a conference level to determine where they think that number is, because the injunction and the NCAA legislation did not have a specific number as referred to these charts that are in the.
So one of the areas that I'd like to clarify, for instance, you're a basketball player, Williams-Marion, I'm at Maryland. So theoretically, they could offer us, you a scholarship to Harvard Law School or me to Harvard Medical School or whatever, or wherever else I wanted to go. But I want to clarify, because you made that comment about recruiting. Those can only be offered while they are eligible at the school. They can't be offered before they enter the school. So those aren't really recruiting inducements. Is that how you see it?
I actually think that schools can, offer that as part of their package to potential recruits. They can say, hey, recruit X, if you come here, in addition to getting a COA scholarship, we're going to give you a law school scholarship when you graduate to whatever law school you want to go to.
Yeah, when we were looking at the NCAA questionnaire, and we think that in those cases that it might be only offered while they're eligible in an institution, but that remains to be seen. What do you think individual schools are going to do compared to the conferences? Do you think can an individual school say, "Hey, I wanted to go way beyond my conference"? What kind of flexibility do you see in the way this is written?
Yeah, I think there's actually a lot of flexibility right now. I haven't heard of any schools or conferences that have set any limits around this. And one thing to touch on is that per the injunction, the conferences are allowed to set their own limits. Schools can set their own limits. The only thing that cannot happen is you can't have multiple conferences getting together agreeing on limits. You couldn't have the SEC and the ACC saying, all right, guys, we're going to set these limits for our athletes. We're going to agree to not go higher than this. That would be another antitrust violation. But the SEC could set its own limits that its schools could not go above. So I think some conferences will probably do that, set rules and limits that their schools have to follow on the cash awards and incentives, and they can do it for the educational benefits like scholars, post-grad scholarships, and things like that as well. If a conference doesn't set any limits, then the schools in that conference are free to do what they want. And I think you'll probably see some limits at the institutional level as well. Um, there's varying uh, opinions within Division One about what it means to be a student athlete. So I'm sure there will be some schools that might completely restrict cash awards or restrict post grad scholarships, while others will go right up to that limit. And same thing at the conference level. I assume there will probably be some conferences that may say we're completely restricting cash awards for academic and graduation incentives, and we're limiting the educationally related benefits that can be given. So I think you're going to see a number of different approaches. So it'll be really interesting to see what the conferences do, and if the conferences don't do anything, what the individual schools will do.
Yeah, I'd like to get your perspective on, the cynic might say, oh boy, this is just disguised pay for play. I mean, they're just going to ramp up these benefits, use it in recruiting and da da da. And then the other side of it would be that they're doubling down on academics. They're making academics a high priority, and they're giving the tools and resources to make it a high priority. How do you which side do you weigh in on?
I do agree with you that if you do this right, you can definitely encourage student athletes to focus on academics. If you have a system where if you hit a certain GPA, or if you get, if you make the dean's list or whatever it is, you're getting paid cash for hitting those milestones. That's going to really encourage people to focus more on academics. Same with if you get a post-grad scholarship to law school or business school, you're going to want to make sure that if you have that scholarship waiting for you, that you have the necessary grades to actually get into a law school. So I think if it's done right, it can definitely encourage a focus on academics. But if you set the bars, really low that are easily attainable, then it's probably not going to encourage a focus on academics, as opposed to if you had a bar that it's higher than just the minimum standard.
But aren't those bars set by each individual school? Certainly, the conference can set limits, but the bar will be the school, won't it? And
Yeah, correct. Yeah, so each going to be up to the school, and so I guess it's going to really be what that school's philosophy on these types of awards and payments are going to be. Um, they can make it really easy to attain those cash payments, and then everybody's going to get them, or can make it so it's not as easy to get them, and you actually have to stretch to reach certain milestones.
let's talk about enforcement for a little bit. I mean, one of the precepts of the NCAA is sort of you have kind of even playing fields. Obviously, schools are going to be giving out very different benefits here, and there's not going to be any consistency. How do you create an enforcement model under that scenario?
Yeah, I think enforcement will be difficult, especially if not every school or conference has a written policy, and they just kind of leave it up to the school to just kind of do it as they see fit. Um, yeah, it's especially if it's the school that's giving it to its athletes, and other schools don't know what's going on. I mean, that's usually what happens in NCAA enforcement. Is one school hears about something, and they'll go to the NCAA and say, "Here, I heard about this. You might want to look into this." But yeah, it'll be another thing that, number one, compliance people at the schools will have to be paying attention to, and then the enforcement at the NCAA level could also be difficult. Um, yeah, that's a good question. It'll just add another another issue to the enforcement plate, and I don't know what the NCAA's plan for dealing with that is going to be.
Yeah, one of the slippery slopes that I see is that the whole idea of the post eligibility internship. Now, let's assume that it can only be offered while the kid's in school, not before as a recruiting tool. But irrespective of that, if if X school is continuing to give kids jobs post eligibility, and every kid that doesn't go to the NBA or on to pros gets a job,
Right.
which is a post eligibility internship, if you want to
Mm-hmm.
call it that.
Yep.
I mean, that sets up a whole new arms race here that is disconcerting. How do you see that?
Yeah, that's a good point. As you said, with the emergency legislation that the NCAA put out in the injunction, they're allowed to give post grad uh, paid internships, and there really are not any guidelines or regulations around that have been drafted. So there's questions of what kind of salaries or what kind of how much payment will these internships um, pay to the athletes when they're done. But like you said, I think right now the way it's written, they could guarantee every men's and women's basketball player, every football player, when you're done, if you don't have another job, or if you're not going to go on and play professionally somewhere, we have a job here for you in the athletics department, or we have a job waiting for you with a company that's owned by um, a booster at the school. Um,
And these are unlimited, so
right.
the conferences can't put a limit on this, right?
I don't see that would be hard to put a limit on. I think actually they can. So a conference could say schools in our conference are not allowed to promise or give these post grad internships. They could definitely limit that at the conference level and the school level. They could prevent those. So that could be something that the conferences, early on focus on putting some guidelines around. It's kind of a game changer because there are no limits on how much they can be paid and things like that.
That's fascinating. Talk about the real big elephant in the room here, Title IX, and what that will mean with all these changes.
Yeah, so I think Title IX would apply to both the cash payments and the educationally related benefits. So that the Title IX it governs the amount of financial aid dollars that are going to men and women, and it's based on say you have 50% male athletes, 50% female athletes. The athletic dollars for scholarships that are going to the men and women, they have to be within 1% of those participation rates. So if you're only giving men these cash awards and incentives, that could really throw off your numbers there and get you way out of compliance on that part of Title IX. And then Title IX also regulates the benefits that athletes get, equipment and things like that. It could be interpreted as post-grad scholarships, and computers and musical instruments could fall into that part of Title IX as well. So if you're giving post-grad scholarships for only computers to only males or females, that could really throw you out of whack in that part as well. So it's gonna create some really tricky Title IX issues as well, because these types of things have never, they're obviously new, and the regulations that come out of the Office of Civil Rights have never dealt with these things. So you're going to have to be applying the guidance from the OCR that has, just up until now, just related to traditional athletic scholarship, tuition fees, room and board, books, and COA stipends. But now you're adding on all these other payments, and you're going to have to really track who they're going to, keep close tabs on them, and just make sure you're up on your calculations, men and women, with all of these things. So it's going to add another thing for athletic departments to keep track of, and another area of Title IX compliance.
You know, take your crystal ball out for a while. You've been working on these issues for some time, and think out 5, 10 years. I mean, what you see happening is more and more backdoor benefits going to student athletes. They're not really backdoor now. They're going to be really front door because you can provide them, but still they're not. It's not like it's compensation per se. Um, I've had ads come up to us and say, hey, maybe we should just get rid of the scholarship model. We're going down this road where there's so many add-ons. It's going to be A, hard to track, and B, it's going to create a very murky environment. Where do you see all this going in the next 5, 10 years? I mean, trying to rationalize this structure where kids could be making hundreds of thousands of dollars, not only on NIL, but also hundreds of thousands of dollars on academic related benefits. And if the bar is set low in a school, I mean, this could be quite widespread.
Right. Yeah, I think it's all going to depend on what the conferences and the schools do on setting the limits at that level. But I definitely think, looking into the future, 5, 10 years, I think there's probably going to be, serious consideration about, does the current model of college athletics still work? Are there alternatives that might work better? What those models would look like? There's probably many different options. No athletic scholarships is one option, but then I think you get into the same antitrust issues that you've had with O'Bannon and Alston, where you're setting limits on those. You're basically saying that you cannot give any athletic scholarships, which, based on the court decisions in O'Bannon and Alston, I think would be potentially problematic. But I agree. There's probably going to be some serious consideration about what college athletics are about. How are they going to look in 5 to 10 years? Because I think where things are at right now is probably not what a lot of college presidents ever envisioned for their athletics programs. So what that is going to look like, I think that's a good question. There's probably many different options, and I know lots of people have given thought to this. I know the Knight Commission and others like that have started thinking on things like that, but that remains to be seen. But I think it's going to be people giving some serious thought to things like that.
Matt, it'd be a good time to go back and play, wouldn't it? I mean, Christ, all these benefits, the academic benefits are pretty amazing.
Yeah.
What if you're an independent school and you're not affiliated with a conference?
Mm-hmm.
Can you set your own limits?
Sure. Each institution can set their own limits. They could say, we're not going to allow any cash payments, or we're not going to allow any of these other educationally related benefits.
Or they could go the other way and say it could be unlimited postgraduate benefits. They could be unlimited. I mean, you could give them unlimited computers, unlimited all trips abroad, study abroad.
Mm-hmm.
You could go totally unlimited on that. You might be constrained on the awards,
right?
But you may not be constrained on the other stuff. So an independent school could operate without conference limits.
True. Yeah, they could offer all these things. They could say, if you come here, you're going to get a post-grad scholarship. You can go to law school, you can go to med school, you can go to business school. You're going to get, if you decide you don't want to do that, you're going to get a paid internship when you're done. We're going to pay for you after, the summer of your junior year. We're going to pay for you to go study abroad in Brazil or wherever. We're going to give you top of the line computer. We're going to give you. So one thing is interesting in the injunction. So it specifically mentions computers, science equipment, instruments, but then also it says their schools are allowed to give other tangible items related to the pursuit of academic studies that are not included in the COA calculation. So that gives schools a lot of discretion. What is considered related to the pursuit of academic studies? You can think of a bunch of different things that would fall into that category, and schools can get creative on that and kind of push the line on that. So yeah, especially if you're an independent school without any sort of conference rules on things like that, you can push that limit and see where it is and see if anyone's going to try and stop you.
Let's turn to name, image, and likeness. I saw your recent tweet on Nebraska. Tell our viewers about that.
Sure. So in July, Nebraska became the fourth state to pass a college athlete name, image, and likeness law at the state level. The other three were California, Colorado, and Florida. The Nebraska law is interesting, though, because it gives universities that are in the state of Nebraska discretion on when the law will go into effect. So, if, say, the University of Nebraska Lincoln, they wanted the law to go into effect or to apply to their athletes today or tomorrow, they could make that decision, and athletes at Nebraska could start entering into NIL deals today or tomorrow. It's an interesting part of that law. None of the other state laws that have been passed have that in there. It does have a date. If the school has not decided by this date, which I believe is July 31st, 2021, the law automatically goes into effect. It's either 2021 or 2023. I can't remember off the top of my head at the moment. But if they don't decide to let the law apply to their athletes by that date, it automatically goes into effect on that date. So the schools can either decide to have the law apply sometime before that date, or if they don't decide before that date, it automatically goes into effect on that date.
But theoretically, Nebraska could say, we're going to allow our kids to monetize their publicity rights, subject to what I don't know. I'm not aware of the guardrails in the bill. Are there any guardrails? Or is it pretty open-ended?
It's similar to the other, like California and Florida. Mm-hmm. It's pretty open-ended. I think the only restrictions it has are, conflicts with the current sponsors of the university. Like, an athlete can't, if a basketball team is a Nike school, they can't be wearing, being paid by Adidas to wear Adidas shoes and other apparel while they're playing for the university basketball team, things like that.
But we both agreed that given the pending federal efforts here, that it's probably doubtful that a school like Nebraska would jump ahead of the pack here. Obviously, the NCAA would be forced to take action. But nevertheless, Nebraska is the first state to actually have an effective law right now for NIL. Florida will be in July, but you now have a state that can give NIL rights to its student athletes. And that's pretty significant. I can imagine that other states will copy that just to.
Yeah, I agree. I think other states will definitely copy that. Nobody wants to get left behind in this NIL issue. And if things can't get worked out at the federal level, or if the NCAA doesn't stay on the timeline that it's put out, and states keep passing these laws, and one of them just decides to go ahead and, like, say, Nebraska decides to let its athletes do this, other schools are going to want their athletes to do it as well, because it's going to be a recruiting tool. So it'll be interesting to see what happens going forward with that.
So the moral of NIL and Alston is that if you're a great student and a great athlete, boy, the world is going to be yours in the coming years, both from NIL benefits and Alston. Is that how you see it?
Yeah, assuming that you go to a school where they don't have a lot of limits on the cash payments you can receive for academic and grad awards, or your school's in a conference that has a lot of limits. yeah, you can do pretty well for yourself. You know, you can make about $7,000 per year from the uh, grad awards and academic awards, and then you could tack on a post grad scholarship, study abroad, things like that, and then you'll have most likely the ability to monetize your NIL, and depending on which athlete that is, that could be a significant number. Um, for most people, it's probably not going to be that significant of a number, but you'll have that potential and that option.
Well, to that point, I mean, theoretically, a kid could decide on the recruiting level that he wants to go to a school where, I have the greatest opportunity of getting these academic awards and maximizing my brand on NIL. So, as we get to the close of this, do you have any kind of final thoughts or big picture comments that you want to make?
I just think that this is obviously something that the conferences and the schools are, if they haven't already, it's something they're going to need to start drafting their guidelines and policies for. As we discussed, there are a lot of uh, open-ended issues with some of these benefits. What level of GPA things are what level of GPA you're going to require an athlete to hit to get at these academic awards. There's a million different types of academic or graduation um, guidelines that you could institute. Different levels of things like that. And then, are you going to allow the post grad scholarships, the internships, all that stuff? It could get this could be a lengthy policy that conferences and schools will have to institute. And when you're putting that together, you're going to have to make sure you're within confines of the injunction, within the confines of the NCAA's emergency legislation. So it's going to take a lot of thought and probably time to put together a policy like this. And I'm sure very soon, if not already, there are some schools that have started offering these things to their athletes, or using them as recruiting tools.
Well, Mitt, thanks so much. It makes me think about the future, and we've never seen standardized grade requirements across the NCAA. They've resisted that, but there's going to be a real difficulty having consistency under this model, and this is going to be I think, a challenge for the leaders of college sports in the future. But again, thanks for your insights and all the exciting things you do in your practice, and we look forward to keeping in touch in years and months ahead.
Yeah, thanks for having me, Tom. I really appreciate it.